Hi, Warriors. This is Jalen. I am here with Kate Langmore. She is an estate planning attorney. And Kate, why don't you go ahead and tell us a little bit about yourself?
Thanks, Jalen. Thanks for having me on your channel today. So, like you mentioned, I practice trust and estate law, specializing in estate planning, trust administration, probate, conservatorships, and guardianships.
All right. And how long have you been in practice?
I've been practicing since 2009. I've been in this area of law for about a year.
How are you enjoying it?
It's great. Yeah, I was primarily in family law before this. So I am very interested in your channel and the issues you're covering right now. And I think there's a lot of crossover. So
Yeah, absolutely. And so I'm very thankful that you're here with us and providing invaluable information to our viewership today. And since there's a crossover, a question to you is about, in California, can a client form an individual trust that gives assets to someone other than his or her spouse?
that's a great question. And like many things in the law, it depends, right? So there's some basics to kind of answer your question. I have to take a step back and cover some basics. You can add a variety of assets to a trust. You can think of it like a bucket, right? You can add real property, so that's real estate, maybe the marital home in one of your cases. You can add personal property like jewelry, artwork, that kind of thing. You could add a business such as a law practice or a medical practice, and you can add bank accounts. Also, keep in mind, maybe you've covered this in a previous vlog or will in the future, California is a community property state. And that means that everything acquired during the marriage through either spouse's time, effort, or skill, mostly that would be income, right? All of that is community property, unless you have a premarital agreement or a postmarital agreement. The third point to keep in mind is that in California, if your client does not have an estate plan, does not have a will, does not have a trust, then when one spouse dies, the surviving spouse will go ahead and inherit all the community property and up to 1/2 of the decedent spouse's separate property. And then the final point I just wanted to touch on is the California Probate Code. The Probate Code covers a situation called the omitted spouse. And in an example where, let's say you're representing wife and she marries husband, wife already has an estate plan in place before she marries husband. If she doesn't amend it after the marriage to somehow mention husband and what he gets or doesn't get, then the probate code will kick in and consider husband to be an omitted spouse. In that case, he would take his statutory share of the estate, which would be all the community property and up to 1/2 of her separate property, unless wife took some other provisions, like she specifically disinherited him, or she provides for him in some other way, like a life insurance policy, or husband executed a valid waiver. Does that make sense?
No, it definitely does. I think the omitted spouse is a very interesting area of law, generally from a family law perspective, like omitted assets, I mean. And, you have in trust and estates, you would have an omitted spouse. So it's similar, but also very different. Yeah, whether there's like an individual trust in place and that person decides to put all of the assets in their sibling's name rather than their spouses. Would she need to get her husband's consent or her spouse's consent in order to do this?
Right, right. So let's just take the example of the real property. Let's say that your client wife wants to put her separate property condominium into a trust. Let's say she bought this property before she got married. It's her separate property. She can put that in her own individual trust and give it to whomever she wishes. She doesn't need husband's permission to do that or waiver or anything like that. But let's say the property she wants to put into a trust is community property. It's the house that she bought with husband during the marriage, right? She can't give, she only owns a 1/2 interest in that house. So she can't give away husband's 1/2 interest in the house. She could put her 1/2 community property interest into a separate trust, but she could only give away that 1/2. If she wanted to put a community property asset into a separate property trust, she would need some sort of waiver from husband, namely a post-marital agreement in order to do that.
Is that post-marital agreement, is that attached as some sort of exhibit to the trust, or is it its own separate, living document?
It's its own separate document, and that's a whole other vlog or book upon itself. Post-marital agreements would be its own document. You would want to reference it in your estate plan just to make things clear for everybody.
And once a trust or an estate plan is put together, where does that document stay? Is it recorded anywhere? Does it just stay with the attorneys? Does it stay with the parties, or who keeps it?
Estate plans generally are not recorded anywhere. A deed is recorded to like a real property. But no, generally one of the main reasons people form estate plans is so that it is private rather than having it go through probate, which is a public records.
So the attorney or whoever prepares the documents would keep the original, and then the clients would get a copy of the original estate plan.
In general, the office where I have worked, the client would keep the original and the attorney's office would keep a copy.
Well, do you have any tips for our viewers about how to handle an estate plan matter during COVID-19?
Sure. I think one important thing to do is to review your estate plan. This is a great time to make sure it's up to date if you have one. Make sure that your beneficiary designations are up to date. Do you still want that brother-in-law, whomever, to serve as your successor trustee? Have there been structural changes to your family, like a divorce, death, birth, all those things? And then if you want to make some updates, go ahead and contact your attorney. It should be fairly simple to do a couple amendments, perhaps a restatement if the changes are substantial enough. But don't try to just handwrite changes into your estate plan. I've seen that go wrong in trust administration cases. Just go ahead and do it the formal way. That way you can help guard against possible issues when you do pass away.
Well, thank you so much, Kate, for taking the time to collaborate with me and to provide, again, invaluable information to our viewership, especially for those that are going through a family law matter and they do have an existing trust and they want to potentially modify it or just to revisit it during, COVID-19. I know that there's some like healthcare directives and things like that that should be, reviewed. So thank you so much, Kate.
Thank you, Jalen. It was a pleasure.
All right. Good luck, Warriors. Bye.